Good evening, and thank you for joining us tonight. I am Colin Kilty, a postdoctoral fellow at the Center for Western Civilization, Thought, and Policy, and with the Department of Political Science here at CU. Tonight's event is brought to us by not only those two units, but also the Leroy Keller Center for the Study of the First Amendment, the College of Media, Communication, and Information here at CU, and the Department of History. So I'd like to thank all of those units for their support. And with that, I'm very happy to introduce Laura Weinrib, professor of law at the University of Chicago Law School, and also an associate member of the Department of History at the University of Chicago. And she'll be delivering a talk tonight entitled The First Weaponization of the First Amendment. I'm so happy, in fact, to be introducing Professor Weinrib that I will say only a few more brief words of introduction before joining the ranks of eager listeners. So Professor Weinrib is most recently the author of The Taming of Free Speech, America's Civil Liberties Compromise, published with Harvard University Press in 2016, a book that documents the origins of the First Amendment and economic struggles over the rights of workers to strike and agitate, and over the rights of business to stand free from economic regulation. And a book that I think fundamentally transforms the story we tell, or ought to tell, about the idea of free speech itself, where a received notion of that idea comes from, what actors and events have been central to its development, and what interests it has been and can be used to serve. Professor Weinrib is also the author of numerous law review articles, essays, and book chapters covering topics from family and sex discrimination law to civil liberties and vagrancy to liberalism in the capabilities approach, if we have any philosophers in the room. Weinrib's body of work thus exhibits a really unique combination of legal, historical, and philosophical thinking that makes it, I think, especially well suited to public conversation and debate. Indeed, I think that we're quite fortunate to have her talk to us tonight, not least because of the timeliness of the legal topics that she'll be addressing. But even beyond the legal dimension of Weinrib's work, I find her ability to use the law to identify and illuminate central, inescapable, but often obscured political questions about voice, about power, and about the imbrication of seemingly timeless principles with human agency and conflict to be truly compelling, making opportunities like this evening rewarding for a genuinely wide and diverse, and actually rather large audience like this one. And with that, I believe it's customary for us to give a warm welcome to our guest, Laura Weinrib.
Thank you so much for that introduction and for inviting me here today, and for all of you for coming. It is a real pleasure to be here to talk to you about what I regard as a very important issue that's facing us as a constitutional democracy today. And in fact, it's an issue that seems to be becoming increasingly important with every passing day. So I want to start us off, as you can see from the slide, with a United States Supreme Court decision that came down last spring that many of you may be familiar with. In late June, at the very end of the term, the court issued its long-awaited decision in Janis v. AFSCME. The Janis case involved a challenge to what are known as public sector agency fees. The petitioner in the case was a public sector worker who objected to paying fees toward the collective bargaining expenses of the union that represented him, and who claimed that requiring him to contribute to union expenses violated his First Amendment rights not to speak. In an expected but nonetheless monumental reversal of decades of settled precedent in this area, the Supreme Court held that agency fees are an unconstitutional infringement on free speech, on the free speech of the non-members of a union who prefer not to pay toward those expenses. Okay, so Justice Elena Kagan, who once taught the labor law class at the University of Chicago Law School that I teach now, wrote a stinging dissent in the case. She accused the court's conservative majority of weaponizing the First Amendment in a way that unleashes judges now and in the future to intervene in economic and regulatory policy. This was a bold statement. It attracted considerable attention from pundits, from scholars. It was meant to capture a fundamental change in the meaning and uses of free speech. According to Kagan, the First Amendment was meant for better things. This was an aberration. It was a departure from the way the First Amendment had traditionally been understood. Okay, so in reading Kagan's dissent, I couldn't help feeling that this trenchant prose was partly blunted by historical irony. As it happens, Kagan was not the first University of Chicago labor law professor to fault a Supreme Court majority for invoking the First Amendment to usurp democratic debate about alleged union coercion. Almost 80 years before Kagan charged her fellow justices with anointing black-robed rulers, a professor named Charles Gregory had articulated what was really a strikingly similar complaint. For years, he wrote, the old court was under fire because of its doctrine of substantive due process, developed to make possible the invalidation of local legislative experiments. So this is in 1940. He's writing this. He says, it now seems from the picketing cases of last spring that the new court is perpetuating this error, meaning this substantive due process, the invalidation of local legislative experiments, by means of the First Amendment. So I wanted to open with this pair of quotations because there's both a close kinship and at the same time a yawning chasm between them. Like Kagan, Gregory was lamenting the weaponization of the First Amendment. But the substantive outcome that Gregory was lamenting was quite different from Justice Kagan's concern. The counter-majoritarian development that he was describing was the use of the First Amendment to shield union activity from legislative interference. So the court's then recent decision in a case called Thornhill v. Alabama protected labor picketing as First Amendment expression. This clinched a decades-long effort by labor advocates and their allies to secure recognition of a constitutional right of agitation, as they called it. This included the rights to picket, to boycott, and to strike. Okay, so as it turns out, the organization that pioneered that weaponization of the First Amendment was none other than the American Civil Liberties Union, or ACLU. The ACLU of the interwar period was quite a bit different from the group we know as the ACLU today. When it was founded in 1920, it described itself, and I'm quoting here, as frankly a partisan of labor. It was the ACLU that described, quoting again, the weapons of free agitation and organization to be labor's most powerful tools. And it was in service of labor's goals of protecting those weapons that they had demanded a sweeping First Amendment. And needless to say, the ACLU's strategy seems to have taken an unintended turn. So writing in the Journal of the American Bar Association in 1940, Charles Gregory explained why he considered the court's decisions in the picketing cases that term to be misguided. He said, true liberals in this country no longer look askance at economic compulsion. In other words, if legislatures saw fit to authorize closed shops or to authorize various forms of union discipline, that was their prerogative. Where the court went wrong, according to Gregory, was in calling such coercion constitutionally guaranteed freedom of speech. Okay, so that's Gregory. In Janis, by contrast, the court held that states run afoul of the First Amendment when they authorize the compulsory assessment of agency fees from public sector employees. So this is a bit difficult to parse, I know, so let me just pause here to make it clear. The constitutional problem for Gregory was judicial recognition of a constitutional right in unions to compel participation. The problem for Kagan is, in some sense, the opposite. It's the judicial recognition of a constitutional right in individuals to resist that compulsion. In other words, the extension of the First Amendment to economic pressure, once criticized for excessively empowering unions, today is used to undermine them. The trouble with weapons, of course, is that they can be turned against the forces that forged and brandished them. So it's the path to this peculiar state of affairs that I'm going to try to illuminate for you today. Janis is not an isolated case. Over the past decade or so, businesses and their lawyers and lobbyists have relied on the First Amendment to challenge a broad range of laws and regulations that they consider cumbersome, expensive, or otherwise unwelcome. In other words, the First Amendment has become a powerful deregulatory tool. Scholars have dubbed this perceived transformation in constitutional law the Lochnerization of the First Amendment. This is invoking the notorious 1905 decision invalidating a New York maximum hours law for bakers. During the early 20th century, the United States Supreme Court and its state counterparts used the principle of liberty of contract purportedly contained within the Due Process Clause of the 14th Amendment to strike down a lot of progressive legislation, including minimum wage laws and workers' compensation. And the idea behind the Lochnerization of the First Amendment is that the courts are using the First Amendment today, like liberty of contract during the so-called Lochner Era, to dismantle burdensome regulatory regimes. Okay, so the main thrust of my remarks today, as I've already suggested, is that the Lochnerization of the First Amendment is not new, nor is it aberrational. In fact, I'm going to argue that it began almost the instant that Lochner itself was put to rest. It was embedded in the First Amendment at the moment that the so-called New Deal settlement was struck. And that feature, I think, has some real implications as we think about the future of the First Amendment. So my talk today is going to proceed in three parts. First, I want to present you with a puzzle about the relationship between the courts and the First Amendment, which has everything to do with the legacy of Lochner v. New York. I'm going to give you the standard account of how the modern First Amendment emerged, and then explain why that standard account is inadequate. Then, to better answer our puzzle, I'll argue in turn that the roots of the modern First Amendment are both more radical and more conservative than historians have previously understood. So with that, let's start with the standard account. I should start by saying what I mean by the modern First Amendment, namely the principle that the Constitution prohibits government officials from punishing individuals for the vast majority of their speech, and that the judiciary is charged with enforcing that right and ensuring that the political branches don't overstep their authority. So why the emphasis on modern? Obviously, the words on this screen are hardly new by American standards. What we now call the First Amendment was ratified 225 years ago in December 1791. But as many of you will know, there was no real constitutional commitment to expressive freedom before the First World War. As you can see, the amendment, this was actually third, by the way, on the list that was submitted to the states for ratification, begins with the words, "Congress shall make no law." Until the 1920s, it wasn't considered binding on the states at all. And even with respect to federal laws, courts never really intervened with official suppression. But it's not the case that everyone thought censorship and suppression was a great idea. Debates over free expression flared up periodically in the 19th and early 20th centuries, but often in forms that are unfamiliar from today's perspective. So I want to draw your attention to one such debate in the early 1910s at the height of what's typically called the Progressive Era. So the Progressive Era was a time of rapid social and intellectual transformation. A lot of ideas that had seemed implausible or heretical at the end of the 19th century seemed mainstream by the beginning of World War I. Progressives understood that social and scientific progress required open discussion of ideas. And yet most of them did not think that constitutionalism was the way to achieve that openness. Instead, what they did is they urged legislatures and executive actors to refrain from criminalizing dissent or from prosecuting dissenters. That is, they trusted in a strong state and they sought solutions in the political branches. In fact, the judiciary was the last institution that they would have trusted to protect free speech. Most progressives shared a deep distrust of the federal judiciary and a deep aversion to constitutional rights-based claims. The reason for that distrust is the Lochner-style reasoning I described earlier, with its valorization of property rights and liberty of contract. So at a time of profound economic inequality, the court exercised what we now refer to as judicial review, what was known at the time as the power to enforce constitutional limitations, to strike down the progressives' hard-won efforts to ameliorate inequality through legislation. When progressives saw all this as a big problem for social welfare, and they were so opposed to judicial review of legislation that they tried to abolish it altogether. During the 1910s, progressives proposed a wide range of measures limiting the power of the courts to strike down statutes. Some of these passed, sometimes with the support of figures as respectable as former President Teddy Roosevelt. So I think we often lose track of quite how much purchase these claims had in the progressive era. These were not necessarily radical or aberrational ideas. They were quite mainstream. All of this came to a head during World War I when government actors and vigilantes worked together to enforce patriotism and conformity and to quash dissent. There were thousands of prosecutions. These prosecutions continued even after the war ended. Multiple public figures, including the socialist presidential candidate Eugene V. Debs, ended up in prison for opposing conscription or American intervention in the war. Neither courts nor government officials stood in the way. Now, I've told you that until World War I, the First Amendment as we know it, as a judicially enforceable check on state suppression of free speech, simply didn't exist. During the war, almost no one thought that the First Amendment was an obstacle to the prosecution of anti-war dissenters. In fact, even the scholars and judges who were most anxious about the repression were really hesitant to solve the problem through judicial enforcement of the First Amendment because they were so deeply suspicious of judicial review. Now, you may be familiar with the traditional story of how that changed, which goes something like this. The wartime repression was so bad that a few pioneering progressives saw the light. In particular, two celebrated Supreme Court justices, Justice Oliver Wendell Holmes Jr. and Justice Louis Brandeis, began to write stirring dissents in decisions upholding the convictions of anti-war speakers. And their reasoning, this account goes, the reasoning was so persuasive, it was so obviously right, that eventually they convinced their fellow justices. But there's a problem. This neat little story, which is largely about timing. For more than a decade, these progressive theorists and academics were in a tiny minority. If Holmes and Brandeis were so persuasive, why did it take such a long time for the Supreme Court to start striking down laws as incursions on the First Amendment? Why did the wayward justices finally come on board? And relatedly, and this is, I think, the most important point, how did progressive advocates come to trust in the courts as the appropriate institution to enforce free speech? Throughout the 1920s, esteemed progressive outlets like the New Republic declared that legislatures, not the courts, were properly tasked with policing the First Amendment, and that civil liberties groups should be seeking the repeal of unjust laws, not their invalidation in the courts. So whether and how progressives eventually embrace judicial enforcement of the First Amendment is the puzzle I'm going to turn to now. We have arrived here at part 2, the radical roots of the First Amendment. And the protagonists of this act are not the progressive theorists and judges we ordinarily associate with the First Amendment in the interwar period. Rather, they are a group of lawyers and activists. And in particular, I'll be focusing here on the early leadership of the ACLU. It was the ACLU's organizational precursors that litigated and lost many of the best-known First Amendment cases during World War I. But what's most important about the ACLU, for today's purposes, is not its wartime activity on behalf of anti-war protesters, but rather its staunch commitment to a radical wing of the American labor movement. Okay, so let me start here by clarifying that organized labor in this period disliked the courts just as much as progressives did, probably more. During the late 19th and early 20th centuries, the courts relied on the same principles at stake in Lochner-style cases to issue injunctions against strike activity. So these labor injunctions, as they're known, emphasized the property rights of employers, as well as the individual autonomy of workers who didn't want to be part of unions. Courts routinely issued injunctions based on nothing more than a claim from an employer that a strike was interfering with its right to maintain production and would damage the employer's business. So without hearing testimony, the court would enjoin any further picketing. Anyone who disregarded the injunction faced huge fines as well as prison time. So as you might imagine, this had a profoundly detrimental effect on labor organizing. Okay, so like their progressive allies, labor leaders hated the courts. What differentiated the two camps was that many labor leaders hated other state institutions as well. Police officers and state and national troops typically intervened on behalf of employers in labor disputes. Striking workers were often arrested, they were sometimes killed, and for the most part, organized labor regarded state and federal officials as tools of industry. To oversimplify then, the defining feature of the ACLU, as compared with progressive advocates of free speech, is that the organization disliked the state even more than it disliked the court. And they were willing, the early leadership was willing to use the courts to check state power. Roger Baldwin, the ACLU's co-founder, would actually have preferred to rely on other methods. He was quite explicit about that. So he preferred methods like grassroots agitation and direct action. But eventually he resigned himself to the fact that, as he put it, the middle-class mind works legalistically. That whenever rights are violated, the first thing they want to do is get a lawyer and go to court. Okay, so if restraining state power meant invoking judicial process, the ACLU was willing to make that bargain. I can't give you today the full origins of the early ACLU, but I will say that Baldwin was a key player in the organization's development. He began his career as a progressive reformer, but by the end of World War I, he was a member of a deeply anti-statist labor organization, the Industrial Workers of the World, and he had involved his organization in defending the IWW from prosecution. Baldwin took his opposition to the state seriously, as you can see. In fact, he went to jail as a conscientious objector to the draft. And when he came out, he told reporters that he would never vote again, that he would never serve on a jury, because the state inevitably served the interests of capital. Okay, so this sounds presumably jarring from today's perspective. But Baldwin was not alone. There were a number of people within the early ACLU who more or less shared his views. So how did these radical labor aspirations work their way into the ACLU's agenda? In explaining this, I want to emphasize that the vision of free speech espoused by the early ACLU is not the one that we ordinarily hear about when we speak about civil liberties in the interwar period. To be sure, the ACLU invoked and even pioneered the now standard defenses of free speech. So, for example, that open debate advances democratic legitimacy, that it encourages political participation, produces better policies, serves to channel dissent into peaceful rather than violent outlets. They said all of these things, and in many cases, they said these things first. But what the ACLU was after was not primarily the familiar model of free speech we have today, so the freedom of leafleters and soapbox speakers to propagate their ideas. Rather, the ACLU had in mind something much more dramatic. And I want to emphasize this, something that is today almost entirely outside the domain of protected First Amendment expression. What they wanted to protect, what they called the right of agitation, was a right to secure fundamental social and economic change through economic weapons. The term they used, without state interference. And what they described as falling within the right of agitation was an absolute right to picket, boycott, and strike, including mass picket and secondary activity. Okay, so for those of you who are rusty on your early labor movement tactics, let me just give you a sense of what First Amendment protection for this kind of activity would have meant, what these weapons were that they were trying to protect. So let's say you have a small local manufacturer in Wyoming that's managing to undersell unionized competitors by paying less than union pay scale. Maybe the employees there are satisfied with the situation because the local cost of living is low. Everyone knows that the lower wages are the only way that those local businesses can stay afloat. Okay, so the union approaches the employees and tries to organize them, but they say, no, we're not interested. Today, that's the end of the matter. Workplace democracy has come to mean that the employees at that Wyoming factory get to decide. They have the choice, the decisional autonomy to determine whether or not to unionize, and that's the end of the matter. The tools of secondary activity, and I want to say these tools are unlawful now, just like they were then, would give the union another much more powerful option, one that's essentially off the table today. If union density is strong, and there's a coordination between unions in different areas and industries, the union can go to the Wyoming manufacturers, suppliers, and distributors, let's say they're unionized businesses in Colorado, and call those businesses' employees out on strike so that the suppliers and distributors have no choice except to sever ties with the manufacturer that's not recognizing the union and isn't paying union wages. Okay, so that's the secondary strike. It can also forbid, the union that is, can also forbid union members from purchasing the products of any business that continues its relationship with the manufacturer. That's the secondary boycott. And the union can enforce those policies by threatening to expel from the union anyone who fails to comply, who buys that product or who crosses the picket line. Now, let's layer on to this. Let's suppose that the union at one of those suppliers has a closed shop agreement with the employer, meaning the supplier has agreed to employ only members of the union in good standing. Now, that's illegal today, but it was not uncommon in the early 20th century. So now you're in a situation where you have called a secondary strike in Colorado over a labor dispute with a non-union company in Wyoming, and those Colorado workers, who employer has some sort of relationship with the Wyoming manufacturer, have no choice except to go out on strike or risk losing their jobs. Okay, needless to say, this was really powerful stuff. It was extremely effective in a time when it was very difficult to make headway using other sorts of tactics. It was very powerful, and as a result of its power, courts almost uniformly enjoined it as coercive. And we have to understand, when we're thinking about the origins of the First Amendment, when we're thinking about advocacy for free speech during this period, that this, not just socialist leaflets, is what the ACLU wanted the First Amendment to protect. This was about keeping police officers from breaking up picket lines and from arresting union officials. Okay, so I can't give you the full account of the ACLU's early origins today, but I will say that Baldwin was a key player in, I'm moving onward, right. I can't really do justice, I was going to say, to the story of civil liberties in the 1920s. Suffice it to say that the right of agitation was not the kind of program that was likely to get much buy-in from mainstream progressives, let alone from conservatives. The ACLU's project, its ambitions, were essentially unattainable in the courts and to a certain extent in the domain of public opinion during this period. So over the time, the ACLU hit upon some more subtle long-term strategies. It expanded its operations into areas like academic freedom, artistic expression, and sex education, in which it could get broad-based consensus. And it did things like challenging procedural irregularities, factual determinations, rather than pushing aggressive First Amendment claims. And so it began to achieve, in this way, some small victories in the courts. Okay, so happy to talk more about that process in the Q&A. What I want to do now is fast forward to the 1930s and to the election of President Franklin D. Roosevelt, which presented a fundamental challenge for the ACLU's vision of civil liberties. For one, New Deal efforts to regulate labor relations introduced a strong role for the state in brokering disputes between workers and their employers. This was at odds with the ACLU's earlier anti-state position that I talked to you about a few minutes ago. In fact, in 1934, the ACLU's annual report cautioned that the dramatic expansion of federal power raised the specter of, quote, dictatorship by the president. Okay, so that's a statement we'd certainly expect the ACLU to make today about Donald Trump. It's a pretty striking statement from the standpoint of post-New Deal liberalism, looking back, that the ACLU made that statement about FDR. But even more than the disagreement about state power, I want to draw your attention to a related debate within the civil liberties movement, which is also increasingly relevant today, and that was a debate about the role of the courts. Because as it happened, the New Deal presented an opportunity on that front as well. During the early 1930s, as Congress began to experiment with bold new projects to mitigate the effects of the Great Depression, the Supreme Court continued its practice of striking down social and economic legislation. In fact, it struck down some of the New Deal's most important programs. By all accounts, the Wagner Act, that bill that you just saw in the previous slide, was on the chopping block. This was the New Deal's signature labor law, and the expectation was that the court would invalidate it. By early 1937, liberals were infuriated. As in the 1910s, there was substantial public will for court curbing legislation. Eliminating judicial review, which is what many of them wanted to do, would mean that Congress could pass, say, minimum wage legislation without worrying that the court would strike it down as unconstitutional. But most contemporaries assumed that it would also mean something else. it would remove the court from the business of enforcing the First Amendment too. And by the same token, preserving a role for the court in enforcing civil liberties would necessarily legitimate its enforcement of property rights. So this sentiment was expressed in a pamphlet circulated by the fledgling National Lawyers Guild, judicial protection for civil liberties by means of the power to invalidate laws cannot be separated from judicial protection for the selfish interests of large property, explained this pamphlet. Okay, so by this time, the ACLU had become an established and important liberal group, and it couldn't avoid weighing in. To arrive at a position, what it did is it polled a number of lawyers and public figures, most of whom were fine with court curbing measures, or at least ambivalent about them. And in the end, the ACLU issued an equally ambivalent report. That report highlighted the power of judicial review to safeguard the rights of political and racial minorities, but it concluded that the Supreme Court was much more likely to uphold property rights than to uphold so-called personal rights like civil liberties. Okay, believe it or not, ambivalence was about as enthusiastic as any liberal group got in the 1930s when it came to judicial review. For the most part, the ACLU's New Deal allies were happy to limit the power of courts, whatever that might have meant for the judicial enforcement of the First Amendment. So just to emphasize, it's not that these groups were not concerned about the suppression of protest activity. They were. On the contrary, many of them were on the front lines of the decade's big labor battles. Many of them had been arrested for organizing rallies or for picketing on the public streets. But they were skeptical that the court would ever protect truly effective protest. And they believed that in the long run, judicial review would do more harm than good. Okay, so the consensus among progressives during the New Deal was that rescuing the country from the poverty and inequality inflicted by the Great Depression had to come first, and essentially that preserving judicial review would stand in the way. What did they propose to deal with this problem? Public figures floated everything from jurisdiction stripping measures to a legislative veto of judicial decisions, to supermajority requirements for invalidating legislation, to a constitutional amendment to abolish judicial review. If you've been following the news in recent months, you will have heard many of these same proposals being floated today. They almost invariably had their antecedents in the New Deal period. There was a lot of momentum for some of the more moderate proposals. So why didn't court curbing legislation pass? I want to suggest that the answer has a lot to do with civil liberties, though not in the way that one might expect. And so this brings us to part 3, the conservative roots of the First Amendment. Until the mid-1930s, conservatives had relatively little to say about the First Amendment. So free speech was often included in the list of liberties that courts were meant to protect from popular majorities, but almost invariably, liberty of contract got much higher billing. And when it came to actual First Amendment challenges by radical defendants in court, conservative commentators almost always came down on the side of conviction. But during the New Deal, conservatives woke up to the appeal of a strong Bill of Rights. The story here is basically the flip side of what I've said about liberal ambivalence about judicial enforcement of the First Amendment. So as liberals' attacks on judicial review became stronger and became more plausible, conservatives were casting about for a cause that would rehabilitate the judicial reputation. And they found it in civil liberties. The real turning point came in the spring of 1937 when President Roosevelt announced his own solution to the problem of an unresponsive court, namely his so-called court packing plan. The court packing plan would have enabled Roosevelt to appoint up to 6 additional justices to the Supreme Court. Conservative groups quickly denounced the plan as a step in the direction of fascism and totalitarianism. One of the most vocal and influential critics of the court-packing plan was the American Bar Association. At the time, the ABA was quite a conservative organization, and the ABA mobilized a massive publicity campaign against the bill. When a committee brainstormed potential lines of attacks, it concluded that its, quote, best idea was to emphasize the court's decisions in civil liberties cases. Now, as events unfolded, court-curbing legislation never ended up going through. Perhaps the ABA's appeal to civil liberties is part of the reason. The ABA thought that was the case. But the more significant reason, no doubt, was that it lost its urgency. In the spring of 1937, the Supreme Court began to uphold New Deal legislation, beginning with a state minimum wage law and quickly proceeding to the Wagner Act. You may have heard this referred to as the switch in time that saved 9. But the defeat of the court-packing plan did not spell the end of conservative support for civil liberties. As I mentioned, when conservatives first took up the civil liberties cause, they anticipated that the court's protection of free speech would accompany and legitimate its property rights cases, not replace them. Most New Dealers assumed that judicial review came as a package. So the idea here was that in the absence of constitutional amendment, expansion of the First and 14th Amendment to protect personal rights would inevitably buttress the court's economic due process doctrine as well. That was the understanding. The court's spring 1937 decision changed all that. And in the new legal landscape, the conservative strategy quickly morphed. So conservatives were clear that they would have revived Lochner-style substantive due process, liberty of contract, commerce clause, et cetera, if they could have. But as it became increasingly apparent that doing so wasn't in the cards, they quickly discovered the power of the First Amendment as an independent check on government authority. So as the ABA's president explained in announcing a new Civil Liberties Committee in 1938, a vigorous First Amendment might prevent the trampling of well-worn shoes, but it would also come into play, this is quoting, when the crushed toes were encased in patent leather footwear of the wealthy, or the rights denied or the privacy invaded were those of the business corporation. In other words, the ABA understood that this could be flipped, the First Amendment could be flipped to protect not just workers' rights, but the rights of corporations. Business groups came on board too. So like the bar, the American industry was facing a formidable public relations problem during this period, and it resolved to recast industry, quote, as the friend of individualists and minorities, a bulwark of freedom. Faced with dwindling public enthusiasm for unchecked economic competition, which had been the sort of the line, the National Association of Manufacturers launched a public relations program to, quote, recreate a public understanding of the vital interrelationship between private competitive business and personal and political freedom. And a few years later, it felt that it had succeeded, that it had managed to, quote, link free enterprise in the public consciousness with free speech, free press, and free religion. Meanwhile, the U.S. Chamber of Commerce demanded constitutional protection for commercial speech. In 1940, its journal dismissed the notion that the right to canvass for the purpose of winning converts to a religious sect is more sacred than the right to go from house to house selling goods. According to the Chamber, advertising promoted not only goods and services, but also the American way. Okay, so coming to the end here, I'm just going to mention a couple of things about how this transformation played out. So first, in controversies over the First Amendment rights of businesses and corporations, the ACLU sided with business groups and parted ways from the labor movement as well as from New Deal administrators. The decision to do that nearly tore the ACLU apart. But I want to emphasize that this wasn't simply a matter of the ACLU abandoning its original goals. Rather, the ACLU felt that protecting business speech, even when it seemed more coercive than persuasive, more economic than expressive, was the only way to ensure that picketing and boycotts would be protected too. For a brief time then, it seemed like that gambit might work. So here we've finally arrived at the court's 1940 decision in Thornhill v. Alabama, and to the reaction of that University of Chicago labor law professor I opened with, Charles Gregory. In Thornhill, the court announced a First Amendment right to picket on the theory that picketing communicated political and economic ideas. When Gregory accused the court of repackaging substantive due process in the guise of the First Amendment, he had in mind all of the history of judicial interventionism in the labor domain that I've been describing to you this evening. In short, he was in 1940 lamenting the Lochnerization of the First Amendment. In the face of criticism like this, not to mention the wave of disruptive labor activity that followed, the Supreme Court quickly whittled away at constitutional protection for picketing. In fact, within a decade, virtually everything the interwar ACLU had accomplished to afford protection to labor tactics had been undone. As the dissenting justices observed in a 1957 case upholding an anti-picketing injunction, the court had declared a formal surrender from its First Amendment protection of labor speech. But by then, the ACLU and the First Amendment served other ends. The ACLU never again retreated from its support for judicial enforcement of the First Amendment. And for many years, most Americans took it on faith that the ACLU got it right. That a strong First Amendment, a strong judicially enforceable First Amendment would preserve a platform for transformative political ideas. The dominant understanding of the First Amendment during this period was infused with an aspirational commitment to participatory democracy, to minority rights, and to peaceful social change. For this generation that came of age with McCarthyism, that came of age with the Civil Rights Movement, the First Amendment was what protected peaceful democratic protest from a potentially repressive state. Okay, so where then does all this history leave us? Okay, so the free speech consensus of the mid to late 20th century has begun to fracture. This will be evident to any of you who follow the news, right? For the first time in decades, a lively debate has emerged not only over the limits of the First Amendment, but over the extent to which the judiciary should be calling the shots. Now, some of this skepticism comes from progressives who worry that unfettered speech for far-right hate groups have enabled and encouraged violence, from Charlottesburg to Pittsburgh. And of course, some of the skepticism comes from the Trump administration itself, which has launched major attacks on free speech in such domains as press access and libel, and has pressured the NFL to discipline protesting players. Now, to be sure, President Trump has proven an enthusiastic supporter of free speech when it suits his ends. I think the proposed executive order on campus speech is probably the most apparent recent example of this. But he's also broken ranks with many of his own supporters by frankly endorsing suppression. This is a position that was spotlighted in a recent New York Times piece on a new group within the Federalist Society, which is emphasizing, quote, that a free press and public criticism should be encouraged and not attacked. As one of the group's founding members told the New York Times, these are values that might once have been thought so basic and universally accepted that they didn't need defending. Okay, so there's movement on all of these points, and there's a lot to say about these developments and whether our current First Amendment doctrine is well equipped to address them. There's quite a bit of recent literature suggesting that the courts are effectively powerless to stop a president who willfully departs from settled legal principles and who invites the publicity that adverse legal decisions bring. But I want to end instead where we started, with a more specific but increasingly important debate about the judicial policing of activity that looks more economic than expressive. That is, I want to conclude by turning back to Janis, to Justice Kagan, and to the weaponization of the First Amendment. Over the past few years, the Supreme Court has rarely invoked the First Amendment to protect political protest, never to protect labor picketing or boycotts. Instead, what it's protected has been the First Amendment rights of corporations to contribute to political campaigns and the rights of anti-union employers and employees. The empirical evidence suggests that at least half of recent First Amendment victories have gone to corporations and trade groups challenging unwelcome regulatory interventions. Now, I'm not going to pretend that history can tell us how courts should decide these cases today, but I do think it's crucial to understand what the modern First Amendment was meant to achieve and what it has accomplished in fact. So from the standpoint of the early ACLU, the weaponization of the First Amendment turned out rather badly. The organization reluctantly accepted protections for business speech to strengthen the case for protecting labor speech. Yet today, labor's rights to picket and boycott, the rights that became fundamental in the late 1930s, as you saw in Thornhill v. Alabama, those rights are tightly hemmed in. Conversely, the expressive activity of corporations and union adversaries has never been more secure. Okay, so notwithstanding allegations that the recent doctrinal turn is an unprecedented perversion of First Amendment values, that the First Amendment, to return to Justice Kagan's dissent in Janis, was meant for better things, New Deal labor lawyers would actually have considered the court's direction predictable. As Congress debated President Roosevelt's court packing plan, New Dealers bristled against the ACLU's efforts to reinvigorate judicial review. Far better, they thought, to curb judicial power than to create a new tool for the suppression of democratic experimentation. They were all too familiar with Justice Kagan's black-robed rulers. The pamphlet I mentioned earlier, circulated by the National Lawyers Guild, made this point concretely. The only way to protect free speech, it insisted, in the interests of persons instead of wealth is through the elected representatives of the people. Okay, whatever else a strong First Amendment has accomplished, and I don't want to be dismissive of those gains, I'm inclined to conclude that history has vindicated the critics of the ACLU's litigation strategy, who cautioned that empowering the courts to engage in expansive interpretation of the Constitution would inevitably aid corporations as much as, if not more than, it aided unions, with potentially disastrous long-term costs for labor's goals. Certainly, they said as much to the ACLU. The ACLU was on notice that weapons were available to both sides in a battle. Indeed, that was the premise of the ACLU's legal campaign from the outset. As Roger Baldwin reflected in 1934, I have always taken the position that labor made a mistake in being so ethical about not using weapons so often used against it. And with that, I would love to take your questions.
If anyone is interested, If anyone is interested in asking a question, please raise your hand and we will try to circulate the mic to you in due speed. This is easy.
Hi there, thank you so much for this. So I'm interested in where we go from here, and if you conceive of judicial review as something that may be not under attack, but something that might shift in the coming years. So you mentioned that the court packing dispute and all the disputes that came with the judicial review that came along with that were rendered moot because the court started going along with the New Deal provisions, right? And I wonder if the court might start doing something like that with First Amendment issues, right? And might sort of in a move to preserve judicial legitimacy, just, go along with maybe public opinion or go along with an executive order or something like that in order to just keep measures against judicial review from coming up. And I wonder what you might say about that.
Yeah, okay, so I have to preface this with saying that historians are notoriously bad predictors of the future. This is obviously outside of my scholarly expertise, but I think we certainly have a historical precedent for that. I think that that's one of the potential paths that could happen going forward. So I think we're in a situation where the legitimacy of the court is extremely precarious, where the court itself understands that there is a perception that it's one-sided and hypocritical in many of these cases, and that there is immense pressure, as there was during the 1930s, to rethink the composition of the court in the form of court packing or through constitutional amendment. And I think we are seeing signs from this Justice Roberts, that there may be concessions made to stave that off. I mean, we've certainly seen that the court rarely, in the period since the New Deal, has bucked public opinion, or at least elite public opinion, for very long. It will often bring certain areas into line, but it tends not to forge out empirically. Ahead of, it's been shown, has not been inclined to forge out ahead of public opinion in many areas. The historical counterexample is, of course, the Lochner Era, where it sustained that oppositional stance for a very long time. So I think it's anyone's guess how that will play out in the future.
Thank you. Very interesting. What implications, excuse me, I'm sorry. What implications does all of this have for the clash between the First Amendment and the 14th Amendment? Because that will arise up before the U.S. Supreme Court in the not distant future.
Well, so now can I ask, which aspect of the 14th Amendment do you have in mind? The Equal Protection Clause, and sort of, are you asking about the clash between equality and autonomy, or is...
Well, as you are probably aware, here in Colorado, we've had a case that went up to the U.S. Supreme Court and got decided on a procedural issue, really. So I really do see that there's going to be a case coming up with a clash between the First Amendment and the equal rights, anti-discrimination provisions of the 14th Amendment protection.
So, okay, so this is there's a couple of ways to think about this question. When you're talking about a clash of constitutional values, I mean, almost all of these cases, to some extent, involve clashes of constitutional values. You can think of even the labor cases in the same mold, because it's the freedom of association of the unions versus the freedom versus the opt-out rights, the right not to speak of non-members, not to associate. Right. This is a routine problem that the court has dealt with. In the past, in these cases, it has prioritized what we can think of as an absolutist vision of free speech. So certainly hate speech issues have come to the court many times, and the court, most recently in Mittal v. Tom, has said there is no such thing as or hate speech is basically not a category. The equality interests that underlie it are outweighed by the speech interests implicated in the First Amendment. I don't think we have reason again, I don't want to predict the outcome of future Supreme Court cases, but I think that that's the direction the court has been taking. Let me just say that not all of these cases actually do involve necessarily clashes of constitutional values. So often, of course, they're about legislation that is advancing equality versus a constitutional right to engage in speech or not to engage in speech. And there the court has a much easier time of saying that the constitutional right trumps, basically.
I usually just talk real loud. I don't know how to do this. So you were talking about I'm going to ask a more historical question. You were talking about the weapons available to labor that ACLU is seeking to protect, like the secondary boycott and picketing and so forth. And I was wondering whether, it would seem to me the sit-down tactic might be at the edge of the ACLU's willingness to support labor. I wondered about that because I think it gets invalidated by the Supreme Court in, 39 or 40 or something like that. So does the ACLU take a position on that? Are they consistent in their notion of what expression is?
So the sit-down strike nearly completely split the organization. For those of you who don't know what a sit-down strike entails, it's basically occupying the employer's premises on the theory that basically striking workers who are around the machinery, this was the idea in the 1930s, would be less likely to be injured because the employer would be reluctant to bring in guards to beat people up with machinery in the vicinity. And it was also harder to bring strikebreakers in because violence was more likely to arise, right? So if you have strikers on a picket line, you can bring in strikebreakers under armed guard, but if they're in the factory, that's not possible. Believe it or not, there was a time when the ACLU thought that the right to engage in a sit-down strike might be constitutionally protected. This is really hard to fathom from a contemporary perspective because, of course, it is such a clear violation of the employer's common law property rights. But then we have to remember, so was the Wagner Act. The Wagner Act interfered with what had been the unfettered right of a prerogative of an employer to determine whom to hire or fire, and prevented employers from hiring or firing people on the basis of their union activity. And that was also regarded as a profound interference with property rights. And so there was a thought for a time that the sit-down strike would similarly be swept into the rights that the Supreme Court might recognize. The ACLU itself found this one very tricky, in part because it was starting to understand, I mean, speaking of clashes of rights, it was starting to understand these issues in the terms that will be familiar to people today, which is about the rights of employers also as speakers. So the ACLU understood employers to be basically, they understood the problem that speech was premised on the ownership of private property in many cases, and they were really hesitant to make this just about preventing state incursions, but they did get nervous about the idea that recognizing a right to engage in this sort, to basically occupy the premises, sort of went too far and was an incursion on the constitutional rights of property owners and factory owners as well. This was in the same period that they were thinking about the rights of employers to propagandize, basically to issue anti-union literature to dissuade employees from joining unions. This was another innovation that was recognized by the Wagner Act. So employers were prevented from circularizing their employees in that way, and the ACLU really divided over this issue of whether that was a problem or not.
So when you're talking about the FDR plan for the court packing plan, and then you said it loses traction mainly due to the judicial branch coming out with minimum wage laws and everything. Do you think that that was more of a they saw the writing on the wall that it was going to happen, or was that already in the process before
Interrupt you, but by the they, you mean the court?
The court, okay. Yes. So the court sees the writing on the wall that it's actually going to happen, or was this already in place before FDR came out with the court packing plan, and then good timing here, now you lose traction on your plan?
Okay, so there is a tremendous literature on this question, and I do not presume to have my own answer to it. Let me just try to give you the lay of the land here, which is there was a traditional story that this was all politics, and that this was basically a capitulation by the court to save its skin in a period when it thought that there, as you said, that it saw the writing on the wall and crisis of judicial legitimacy, and also just was worried about what this would mean for the autonomy of the courts, and so it switched. So Felix Frankfurter wrote as much during the time. So did a number of prominent constitutional theorists. The idea was that that Justice Owen Roberts was the vote that switched because he was worried about these issues. Then there was a revisionist literature that arose that suggested that, in fact, there had been sort of critical mass on the court to scale back some of its aggressive interpretive mode even before the court packing plan was announced, and that, in fact, in a previous case, Roberts had announced that he would switch his vote, but that he was waiting for the right time to do it. Then the question becomes, and this is the question that is as I said, much debated in the literature, what does that tell us? If in fact it wasn't a response to the court packing plan, if the switch was not a response to the court packing plan, is it? What are the stakes of that? Those who want to see this as a politicized decision by the courts tend to turn to the fact that the 1936 elections nonetheless were sort of a referendum on the popularity of the New Deal, and that a lot of these measures that I talked about, the court curbing measures like jurisdiction stripping or legislative veto of Supreme Court decisions, had already been floated. So that even if the court packing plan itself, and I should say the justices were really anxious about the court curbing plan more than they were anxious about these other more democratically legitimate options as they saw it. Okay, so now I've lost my train of thought. But in any case, there is evidence that they were still motivated by this fear of interfering with the court through one of these other means. But yeah, this is such a contentious issue that there was supposedly a memo that would have given us the answer, which was actually stolen from the archives, and a series of heated debates in law reviews during the 80s and 90s about what that meant.
So I will exercise my prerogative and ask actually about a slide. I don't think it's going to work to go back to the slide, but I thought it was an interesting one, or at least an image on one of the slides that had women, like strike for women with the tailor. I don't remember exactly what the text was, but I thought this one was particularly interesting because those were not the typical kinds of people that showed up in the other images that we've seen. And I'm curious if there was a gender dimension to some of the activism or legal activism that the ACLU was engaged in, and if that complicated the kind of story they wanted to tell about the undesirable trade-off between civil libertarian First Amendment enforcement and then anti-regulatory First Amendment enforcement.
And can you tell me your intuition about why it would have complicated it?
I'm not entirely sure. I'm trying to bring out that dimension to see if that's a dimension that can be brought out.
So, I mean, there's a lot of things to say about this. One is that of prominent women within the ACLU. Many of them had begun as progressive reformers. Many of the founders of the ACLU, because of the prominence of women among these early progressive reformers, were women, and in fact, including co-founder Crystal Eastman. Many of them had been involved in settlement houses and other projects, were social workers. There were also, and for many of them, that was their aversion, that was the source of their aversion to the courts, but it also informed the way they thought about counter-majoritarian constitutionalism in a sense. So this may be getting too far afield, but some of these women were quite involved in early cases like Muller v. Oregon, which were cases about protective legislation in the workplace for women, in which they basically wrote briefs advancing arguments suggesting that women merited additional protections. So unlike men who in these Lochner cases were seen to have contractual autonomy, to be independent parties who were capable of contracting, which made maximum hours legislation an affront to their autonomy, women were sufficiently weak and dependent that they required the assistance of the state. So many of these same women were pushing those arguments in complicated ways in the progressive era. Now, this sort of shifts in the period that I was speaking about earlier. So there, the influential, many of the women who were influential in the ACLU in the 1920s had been involved in suffrage and other causes. But the most prominent and influential women in the 1920s were women like Elizabeth Gurley Flynn, who was a radical labor agitator and organizer and was out on the front lines of labor struggles. These were quite different from the middle-class progressive reformers who had been active in the earlier periods. At that point, there were concerns about whether for example, closed shops. I mean, there were always internal struggles about the effects of union tactics on marginalizing both women and, of course, racial minorities who were often excluded from unions. This was an issue that they were acutely aware of, and that they, frankly, could have done more to address. They were more aware of the problems and were confronted with it and failed to make to get traction on it within the organization or within the civil liberties movement. So in that sense, it does complicate, I think, how we think about their advocacy in this period. That's sort of a labor history story in general, I think, as opposed to one that's specific to the First Amendment side of it.
Can I ask you, and maybe in a somewhat similar vein, to speak to possibly even conjecture about the way the changing identity of the claimants of these rights, particularly in organized labor, might have affected the evolution of the ACLU philosophy about free speech. So to begin with, of course, we have the IWW at the very forefront of radical labor and radical industrial unionism. And then by the 1930s, in the midst of this change, the IWW is gone and has been superseded by a very different organization, the CIO. Is that, I mean, in what sense is that something central to the story here?
Yeah, the CIO and, of course, the other frequent ally of the ACLU during this period was the Communist Party, right? So this shaped their view in many ways. The IWW, in some ways, had greater kinship with them in its state skepticism, right? So, I talked about it's complicated because to the extent they used the courts, they used it as essentially, the strategy initially was, as they put it, to show up the hypocrisy of the courts. This was what they borrowed from the IWW, this idea that you go to court because it's a good way of making a public record that the newspapers might pick up of the the hardships you've endured in labor battles or at your workplace. It was essentially a way of giving testimony. It was also a way of proving that when the courts talked about neutrality and the equal-handed application of constitutional principle, they didn't really mean it. This was, of course, their sort of principal approach, but they all expected to get thrown in jail, as you know. So they basically, the strategy early on was to bring these First Amendment claims with the expectation of losing them. This is what the ACLU's lawyers said explicitly, and essentially this was a way of building enthusiasm for direct action tactics instead, proving that legal channels were eventually going to be futile. I think as the IWW is crushed after the 1919 prosecutions, and as they move on to other allies, they evolve in their thought. Part of this is this idea that Roger Baldwin says, it turns out our clients just don't want to go to jail. They actually want to win cases, and they start pursuing cases that were more likely to lead to victories for that reason. And part of the reason they're able to do this is because their clients are amenable to that, whereas the IWW simply didn't want these half moves and concessions. They wanted to bring these much stronger claims. Part of this is that, another way in which this deeply influenced the ACLU is that these other organizations had quite different attitudes toward the state. So, with respect, I'll say briefly about the Communist Party that the ACLU was often at odds with the Communist Party because of their view that it was legitimate to suppress dissent essentially in the short term in order to bring about inequality. So there was many of these people many of the ACLU leadership traveled to Soviet Russia and sort of became less enamored of the experiment when they saw that the free speech there was not being respected. In fact, there were lots of prominent fights about whether they should, over the course of the 1920s, as the ACLU brought in more lawyers. One thing I didn't say is that the ACLU, when it was founded, only had a couple of lawyers, right? We think of it as a lawyers organization. There were hardly any lawyers. They all come in over the course of the 20s and the 30s. Those lawyers didn't want people skipping bail. They didn't want, they wanted to prove that they were respectable with the understanding that incremental advances in the courts, which was really the ACLU's strategy by this time, would be accomplished better if the ACLU as an organization was respected in the courts. So the last piece of this, I know this is too long of an answer, I'll just say a word about the CIO. The CIO, which in contrast to the American Federation of Labor, the AFL, which had long had what's called a voluntarist view of the state, that basically negotiations between labor and employers should happen outside of state channels. In contrast to that, the CIO by the 1930s said in an era of industrialization, that's no longer a plausible strategy, and the state has to come in to facilitate equal bargaining, and this was because unskilled workers were so easily replaced, et cetera. And so the ACLU's initial deep skepticism of the state actually changed quite a bit through its interactions with the CIO, so that it came to embrace what we now call, what we now associate with Caroline Products footnote 4, or with what's often known as the New Deal settlement, which is this idea that Congress should be free to regulate in the economic domain, just not in areas that are seen as necessary to the full and expansive debate of those policies before they're enacted, right? So the First Amendment is meant on this model to protect inputs into the democratic process. Those need to be protected, but that once democratic majorities make a decision on economic issues, those should be deferred to. The ACLU eventually comes around to that view as well. That was a really fundamental reconception of its attitude toward the state.
since we're probably getting to the end of the time, I'll ask a really easy question. So given that in a lot of ways we think of, and fascinating talk, I really enjoyed it. But since one of the sort of adages that we have about the First Amendment and about free speech is that the only kind of meaningful meaningful free speech to support is the speech you hate, right? Because otherwise it's meaningless, right? So how, like, and at the same time, these are clearly like feel like dishonest uses of free speech, Janis and so on and so forth. So where does one square that circle, right?
This is supposed to be an easy question?
Exactly. This is the easy question that you can tick off.
Okay, so this is, so let me answer this by saying this. I think there is, the one thing that I really want this project to do is to disrupt the idea that there is an only way to do free speech, right? That there's a principled conception of free speech that we as the American people have clung to always, and that departures from that are somehow out of bounds as a matter of principle, because that's simply not been the case ever, right? So, when we talk about how did we get the modern First Amendment, that conception, we got it for particular historical reasons through the advocacy of particular historical actors. Talk about freedom for the speech we hate. I mean, when the ACLU defended the rights of Nazis to march in Jersey City in the 1930s, they were doing it because they knew that judges would never trust them if they went into court, and in fact this is the case, that lawyers would argue they're just defending labor rights. These are just shills for labor, and the ACLU understood that if it wanted to make claims that would be recognized by the courts in a period when the court had not yet recognized a First Amendment right, that the way to do that was to create a neutral principle. And they essentially, were the first organization. There were some historical precursors, but they, for all intents and purposes, invented that conception of the First Amendment. They did it to advance labor rights, which were then very swiftly written out of the First Amendment, right? So this isn't to give us an answer as to how to deal with these problems today, but I really want to be clear about the fact that, speech is regulated routinely in all sorts of ways. We live in a world where communication is through speech. When you regulate, what a doctor can tell you in the doctor's office about medically indicated procedures, or copyright, or securities regulation, you're always regulating speech. And so, as we think about what it means to regulate speech, I think we also have to think about how we got the free speech tradition we have, and what ends, essentially, we want it to serve today.
I don't know if you would like to drop the mic after that. But can we actually get round 2 of applause for our speaker? Thank you very much. It was wonderful.